Will versus trust, which one do you need? Perhaps the hardest part of estate planning is not getting confused. Lawyers like me throw around new technical terms while you are still trying to understand the last words we said. So in this video, I am bringing the discussion down to earth to answer a simple but critical question. A will or a trust? Which one do you need? So what's the purpose of a will? A will directs how your assets are distributed after death. It names guardians for minor children, if you haven't. A will is a fairly simple document that can be changed later. That's a huge benefit, but here's the downside. A will must go through probate, which is public, time-consuming, and a costly process that is often the required way to take legal title to property. However, probate varies state to state. States like California are known to have terrible probate systems. Other states like Texas and Connecticut have probate systems which are faster and less expensive. But here comes another downside. A will doesn't protect assets from a Medicaid lien. Now, what's a Medicaid lien? Well, I spoke to one disappointed heir last month. It's something like this. He was wondering why the state of Connecticut had a lien on the house he inherited from his mom. I had to tell him the bad news, that the government may seek reimbursement from any assets of the deceased from Medicaid long-term care costs, which his mother was on. This client's mom thought a simple will was good enough. She didn't think she had that many assets. She thought after years of paying into the system, there was no need to shuffle ownership around. She trusted the government. So after she passed, the estate spent 12 months in probate, but at the end of it, there was nothing left for her son. It's too bad, as there was a solution to avoid this problem that I will get to very shortly. But unfortunately, too many people don't take Medicaid planning seriously. Okay, so what's so special about a trust? Well, a trust creates a legal entity that owns your assets while you're alive. A trust avoids probate. Assets transfer directly to the beneficiary, as the assets may already be transferred to them. Now, your big choice in a trust is either to make the trust something you can always change. In that case, it would be a revocable trust because you can revoke it. Or you can choose a trust that you can't change or are limited in how you can change it. That's called an irrevocable trust because you can't revoke it. Now, with a revocable trust being so flexible, why would you possibly want an irrevocable trust? Because an irrevocable trust provides asset protection. A revocable trust can be treated like you, as you can change it at any time. Whereas an irrevocable trust is considered to be its own legal entity. Irrevocable trusts are used in special needs planning, in business succession planning, and in Medicaid planning. Medicaid planning is key because even after spending decades paying into the federal entitlement system, failure to plan properly can result in the government being the biggest beneficiary of your estate. Many people underestimate long-term care costs. The downside is that in order to avoid this catastrophic disaster, Medicaid trusts are a little bit more expensive to create and may have a yearly tax return to file. For instance, our will package for a couple starts at $1,800 in legal fees, whereas a Medicaid trust usually starts at around $4,500 and up to set up properly. So let's get to the bottom line. When will a will be good enough? Well, when you have a smaller estate, no real assets to protect, or if you have long-term care insurance, if all your property is in one state and in one country. And again, a trust cannot choose guardians. A will may be a good choice also when you have no time or ability to get a trust, as it may be better than nothing at all. So, when is a trust a great choice? If you own real estate, assets around the country and the world, or a business. If you want privacy and you want to avoid court delays and fees. If you have complex family situations like second marriages, blended families, children with different needs, trust may be the right thing for you. Think of a will as instructions for the probate court, and a trust as a private shortcut that avoids the court entirely. One isn't necessarily better than the other. It depends on your situation. If you're not sure which one fits you, don't leave it to chance. This is Anthony Parent of One Team Legal and Tax, the IRS Medic. Subscribe for more estate planning tips and check out my video on the do-it-yourself estate planning mistakes that cost families millions. I've seen it myself. It will show you what happens when people choose incorrectly.